Welcome back to my channel, True Crime Files with Kathy. Housekeeping rules. If you can click like, subscribe and share, and then that way it helps me out by getting into the YouTube algorithms. I'm doing a part 2 on Lindsay Clancy. I don't know why I go to call her Nancy for, because she's not. Just a little sort of like update on Lindsay. Lindsay Clancy, a Massachusetts mother who attempted to take her own life after allegedly killing 3 of her children. She is still suicidal, according to her attorney. Her attorney made a claim whilst asking that his client can be allowed to arrive at trial in a medical vehicle rather than a jail van. Clancy's trial, which was due to start in February, has now been pushed back to July. So Lindsay is accused of killing her 3 young children and then taking her own life back in 2023. And 3 years later, she's still classed as suicidal. Her attorney, Kevin Reddington, appeared in the Plymouth County Superior Court earlier this month at a hearing ahead of Clancy's upcoming criminal trial, which has now been pushed back from February to July. At the hearing, Reddington requested that Clancy's to be able to travel to and from court in a medical vehicle as opposed to a jail van, which is standard for all jailmates. The district attorney's office opposed the request, arguing that Clancy's arrival in the medical vehicle could cause jurors and members of the public to view her as a victim rather than someone accused of plotting and carrying out the murders of her 3 young children. Mr. Redston argued that failing to meet Clancy's medical needs during a trial could lead to a risk of suicide. They also were saying, I covered it a bit yesterday, they were also saying that if she, they wanted her to come in on a stretcher to give her time to rest, and, that she's still suffering from extreme depression or postpartum depression. But she's able to transfer from wheelchair to bed or to another chair and vice versa. While in prison, she's quite capable of taking, care of her own needs. She can wash herself and bits and pieces, but I can understand why they need probably medical assistance in the court, because maybe the court toilets don't cater for disabled people. So that might be a reason. I don't know if courts have disability access. But yesterday when I did the recording, I couldn't see a reason why she couldn't arrive in a wheelchair and also maybe have one person with her to help her transfer and if she needs toilet needs. So, I'm all for that bit, but they were saying she needs 2 nurses. And at one point, the attorney was saying that if his needs of the client wasn't met and she, unalives herself or causes harm to herself, then that's on the judge's back, basically, which I think was a bit of an unfair advantage. But I could possibly see it that if she arrived on a stretcher and in a, say, private ambulance, that's seen as, more for pity's sake than someone who took the lives of her children. I did go through yesterday the effects and different types of depression after childbirth. Postpartum one, sorry, can take absolutely weeks, and you do get delusions, you do hear voices and things like that. So it's a complicated trial. So I'll play this one, and then obviously when July comes, it'll be part 3, and I will try and work out how I can create playlists. So once again, thank you for coming to my channel. I do appreciate it. And like I said at the beginning, if you can click like, share and subscribe, that I'd appreciate that. Also, because I'm not monetized, so I don't make anything from doing these videos. And, I do use up my time and electricity, etc. If you do fancy buying me a coffee, the banner should be scrolling at the bottom for you there. I've just managed to sort that out. I thought it did it automatically, but obviously not. So I'll go ahead and play this, and I'll only chat if I absolutely have to chat in it for you. Because I know some people like chatting and some people don't like chatting. Just check the volume. Volume's at full speed. I do like their chairs where they can lean right back.
Court, all right.
I will say one thing. No matter who I am, with the attorney there putting his hands on me, I don't think I'd like that. I would, probably cringe at the fact of it. Unless I'm in a relationship or something, I don't like to be touched. And I find if someone comes up and gives me a hug, I find it a bit awkward. Unless it's family, that's different. But from that point of view, where he was like tapping on the wheelchair and then tapped her on the back, I'd cringe at that. I really would. But let's pay.
There's honorable courts now. Step and be seated, please.
Good afternoon, Your Honor. Good afternoon, all. This is called the criminal court list for Plymouth County Act Limit on 2/20/2026. The first case is according to call is number 2 on our list, 4383 CR 198, the case of Commonwealth versus Lindsay Clancy. This case is called for motions for the record of defense president of the bar. Counsel for the record, being with the Commonwealth.
Good afternoon, Your Honor. Kevin Sprague, the Commonwealth.
Mr. Sprague, good afternoon.
And Shannon Buckingham, also for the Commonwealth.
Attorney Bucky, good afternoon.
Good afternoon, Judge Kevin Brady, on behalf of Mr. Clancy.
Mr. Reddington, good afternoon. Ms. Clancy, good afternoon. All right, so this is a matter for a number of reasons here today, I think. But first, I just kind of want to know, we talked about the evaluation. And I know there was a motion that was just recently filed. And by recently, I mean just the last day or so. So I'm not sure we're going to address those motions that were filed. We'll need a new date on those. But one of them that was filed that I didn't know if we could take up, and that's one regarding the taping of the Commonwealth's evaluation. Now, I know we've talked about this for a number of times, so I didn't know if we can address that at the Commonwealth's position. My understanding was that there was no objection to the taping of the evaluation, with the only proviso on that dealing with some of the actual testing. So I don't know where we stand on that.
Yes, Your Honor, I did just receive these motions yesterday, so I don't have any case law to argue or anything like that. But our position was that we had no objection to the recording of the examination of the defendant. We would only object to recording of the testing process because of proprietary rights for the standardized testing.
Mr. Reddington?
I don't know the impact of videotaping the proprietary rights for standardized testing. First of all, I would suggest that like come under W for who cares. We're not here to protect proprietary rights of private businesses and enterprises, number one. Number two, personally, I don't really care about the proprietary rights. My concern is what the actual tests are going to be, how they're going to be implemented, how they're going to be administered. And I can speak to certainly Dr. Zeisel, my consultant who's here today. I can speak with him regarding that. I know as far as the testing is concerned, usually it's the usual judges. You're welcome to Minnesota multi-basic personality, back inventory, all of those tests. So I don't really have a problem with them not videotaping the actual filling out of the squares and the actual test. So I think we can agree that it would be the interplay between the government's doctors and Lindsay as far as them asking her questions and her related statements, that would be videotaped.
I don't know if it comes to.
So they're going to try and stop.
My
Uh,
suggestion is to pick a date to argue this motion prior to, if I remember, sometime early April, the dates that have been set. And that would allow all parties to kind of get media information as to the need for not taping the testing or the no need for it. So then I can fashion a decision at it, but I want to make sure that it doesn't slow down or interfere with the actual testing.
Your Honor, we have the testing scheduled for April 10th.
Right.
I may have misheard, but I thought the defense counsel just said that he had no objection to not recording the testing. So if that's the case, then I think we could come to an agreement.
Mr. Rankin?
Again, I just would like to consult with my own experts regarding that, but I feel myself that I don't really have a big issue with not recording and filling out the little squares and that type of thing. I have no problem.
So what do we do? I'm going to allow the videotaping of that. That will include the testing as well. If either party wants to strike that, or impound that part of it, if we can do that, call.
Could we do the reverse and just order the testing of the interviewing, and if there is some reason that that's.
No, I'm saying, there's no question about, doesn't sound like either side is objecting to the evaluation itself being videotaped. The only issue, it seems to be, is whether or not the testing itself is videotaped. And now I'm hearing it probably isn't much of an objection. So what I'm going to, my suggestion was to allow the taping of the evaluation and testing. And if somebody wants me to reconsider it and come forward with any additional evidence as to why the testing itself shouldn't be.
Well, I think that, it puts the Commonwealth in a position where we received this motion yesterday. I haven't had a chance to research it or respond, and yet there will already be a decision allowing that taping.
But you
that
want to tape
we're objecting to the taping of the.
You know who wants to tape? You want?
I don't want to take the testing portion.
Okay. All right, so why don't what I don't want to do is I don't want to delay the testing.
Right.
So, how much time would you need to, prepare for this, motion?
As you well know, I'm going to try and know Lieutenant Superior, I'm going to carry out probably Monday or Tuesday. I would say a lot of the courts are putting this stuff at 2 o'clock in the afternoon now, so it's a little
Let's have a
difficult.
spring colour, shall we?
The 2nd of March, would that work? It's Monday.
Pretty spread.
I'm preparing for a trial that starts March 9th. Could we do it more towards, March 23rd? And that gives us a
That's
couple
fine.
weeks before the testing is supposed to start?
I don't have a problem, but just so everybody knows, that testing's going forward on that day, no matter what.
I apologize, I just looked, I was dealing with, judges saying for a triple homicide on that day.
Which day?
The one you just mentioned, which would be, I think, the Monday.
Oh, you suggest the 23rd?
No, that's right, no, not March 2nd, it was the 23rd of March. Right, I was handling it while we were looking. I mean, I could do, I
They certainly like viewing into it, don't they?
Really, if you throw out there,
Yeah, Trav.
Wait a second. I know
That's fine.
Before purpose, and I don't want to jam you up, in regards to that, but, it sounds like, quite frankly, that may or may not really object to the testing. He just wants the opportunity to speak to, his doctor. And so it may not even, need a hearing in regards to that. But if it is, it's gonna be a fairly short hearing. Most of this could be done through affidavits if parties have an objection to it.
What we probably want to know is what is it, when they say protection of their proprietary rights, what is it they're concerned about? Is it that they don't want to videotape the filling out of the forms, or is it the actual content of the test? And, yeah, I just don't know.
And I don't want to put the come up in the middle of the season. I know that you're dealing with other parties who want their position made known to the court. So I think we can do that. Most of it can be done through affidavits. Then I can take a look at it. And if we need it, we can have a short hearing on the second. Does that work?
That's fine.
Okay, all right. So the motion regarding videotaping will be on for March 2nd. Other than that, in regards to the evaluation, are there any issues regarding the discovery that's required under Rule 14.4, I guess now, that's required prior to the evaluation? Is the Commonwealth satisfied that they have what they need?
Defense counsel has stated that he's turned over everything his experts have reviewed and all of the raw data from their testing. So relying on that, I don't believe there's anything else at this time.
All right, and if anything comes up, just a little bit, I'm kind of going through my checklist to make sure that we have everything. So it sounds like the discovery for the evaluation is complete. There were two other motions that were filed. One is regarding juror information, and the other is the motion to bifurcate. Is that something we can argue in a second?
Yes.
Well,
Yes.
all right, why don't we do that? Because I just got those two, I haven't reviewed them, but they'll give me a chance to go over those motions as well. So if the parties talked about, again, under, the three of you know this very well, but in regards to the exchange of the document reports, is there an agreement in regards to when Commonwealth's report is issued? Is there an agreement between parties that there'll be an exchange of the defense report as well as the Commonwealth report?
We haven't talked about it, but as soon as we have the reports, then to turn them over and request theirs in return.
That's my practice, Your Honor, is that once the government's doctors file their report, I provide ours to them and vice versa.
And then, but, so when you get there, if that's any different, then just, we can address that in court, but that's been my experience as well. When they're both ready for the exchange between the parties. Now, in regards to scheduling, well, we don't get the July date, probably, then, I thought, working back a little bit, is maybe a final trial conference date, rather than a week or two in, that my thought was maybe sometime in early June, because I imagine there'll be significant motions to eliminate, we'll have to address, and that'll give us time in case anything has to be kind of followed up on prior to the trial. But I kind of just wanted to bounce that off of the three of you. What are your thoughts? Come on.
I think that makes sense, Your Honor. I would keep the final pre-trials date set for July 13th in case any last minute issues come up, but I think it makes sense to have an earlier one as well.
Ms. Reagan?
I agree.
Yeah, so we'll keep that July 13th. That's kind of a true final trial conference we have. But we can pick a date maybe sometime. We need to deal with motions to eliminate. council are looking at the week, first, for the 8th, and the 4th, 5th, 11th, 12th.
I'm sorry, scheduled to start a trial in federal court with Judge Saris. It's going to go 2 weeks on the 1st of June. So I'd say the week of the 15th. Yep, that's fine.
How's that?
That's fine.
All right, so that'll be the final trial conference. Parties can have their motions to eliminate filed the week before. Then we can address any of those time.
Does that work with you with your trial schedule?
If it doesn't, I'll call you at the beginning of the stage.
Well,
Yeah, that works.
All right. And then,
I'm sorry, you said a week before or 2 weeks before?
what do we say, 2 weeks?
2 weeks.
That's probably better for everybody's preparation. In the court. All right, the other thing is, on March 2nd, we're gonna deal with those motions. The defendant's request, that she be brought in or by Zoom just for those quick hearings.
I'd like to have it here. And I have to, if I may, on that issue, I would actually, strangely enough, like to commend the sheriff's department and our staff in Tewksbury that melded together incredibly and done just a marvelous job of transportation and supplies and taking care of our ancillary issues. So I just wanted to put that on record. Appreciate the help the court provided in that regard as well. I would like to have it here if I could.
So we'll see that, kind of gives it kind of a short runway, so we can we'll try and get that done.
Okay.
If not, we can't get that done,
Not critical. I mean,
yeah, we may have her on vice.
That's fine.
That's all.
Understood.
The other thing in regards to that, I know the court issued an order regarding the procedures, which is sealed because mainly dealt with security issues. I also just kind of wanted to let council know, and it's in the order, if either side or any of the parties feel that order has to be amended or changed, just bring it to the court's attention.
Of course.
Okay.
Thank you.
All right.
Now, if I could just ask, the March 2nd date and the June 18th date, are those at 2 p.m.? Or,
If we can, yeah. Does that work for you?
It does, I just wasn't sure if we wanted more time for the motions than Monday.
June 18th?
yes,
I think we should do the morning of that. Right, I was thinking it's March 8th. Yeah, June 18th is, I don't know how long that goes to be, so we'll do that. And let's see, 10 o'clock.
10 o'clock? Thank you.
In regards, other than that, anything else that we need to address, first call?
No, Your Honor.
Defendant?
Have a good one.
All right, so we'll be in recess on this matter until we would say March 2nd. And at that point, we'll deal with those motions that have been filed, any other issues that we have to. We've got the trial date, the 2 final trial conferences. And then if there's any issues regarding discovery, especially under Rule 14.4, parties can bring it to my attention, we can deal with that.
Okay.
All right?
Thank you.
All right, so that will be a recess on this. Thank you.
Thank you.
Typically, 26, yeah, motion. Come on, all right. Court is in recess, please stay at order.
I'm not on stage. So I appreciate everyone's coming in and watching me. Please click like and subscribe. As I said, it does help me to get into the algorithm. Thank you.